Good morning, everyone, and welcome to the McCarthy Institute Presents Series, Episode 3. We are thrilled to have all of you here today. I'm Kelsey Anglin with the McCarthy Institute. In just a few moments, we'll kick off our panel discussion, but a few housekeeping items before we launch into today's discussion. First, if you would please use your chat feature and give us a shout out, let us know where you're joining us from. We'd love to see where everybody is coming in from around the world. I know we have people coming literally from around the world joining us today. Also, be sure to use the Q&A feature in the webinar room to ask questions throughout the session this morning. Our panelists will be addressing questions during the last portion of our time together, and be sure to use that Q&A. If you see a question that you're interested in, go ahead and use the upvote feature. That'll pull it to the top of the panelist queue for answering during Q&A. Lastly, there are a couple of potential points in our presentation today where we may ask for some polling. You will see at that point a poll come up. Please be sure to answer the question appropriately for yourself, and then we'll share those results and our panelists will move to discussing those. With that, I'd like to introduce to you David Franklyn. David is the director of the McCarthy Institute, and he'll be introducing our panelists this morning. David.
Good morning, everybody. Welcome to the third episode of McCarthy Series Online. Today is USPTO versus Booking.com, what a recent Supreme Court case means for trademark law. I'd like to introduce our moderator, David Bernstein from Debevoise and Plimpton, and he's going to take it away from there.
Excellent. Thank you very much, David, and many thanks to the McCarthy Institute for hosting this webinar. It's amazing to see some 350 people already signed on from literally all around the world, so it shows the extraordinary interest in this case. Next, Kelsey. So I'm going to give a quick overview of sort of how we got here, and then I'm going to introduce our panelists, and I'll let you know more about where we'll go from there. This case goes back to 2012 when Booking.com, a company I hope everybody knows about, one of the world's leading travel websites, applied to register its name, Booking.com, as a trademark. After a couple of years of prosecution, the USPTO refused that on the grounds that it was generic, that booking is generic for a website at which you can book reservations, and that adding a .com TLD doesn't change that. The TTAB affirmed, at which point Booking.com sued in federal court in Virginia, as is their right, and the federal court reversed. The federal court found that Booking.com is not generic as a matter of law. That went up to the Fourth Circuit, which affirmed in a decision that was 2-1. The US government sought certiorari, which was granted, and the Supreme Court specifically asked for the parties to brief the following issue: whether the addition by an online business of a generic top-level domain .com to an otherwise generic term can create a protectable trademark. So for purposes of this appeal, they were accepting the notion that booking is generic, and the question was whether a generic term plus .com is automatically generic, so-called generic .com domain names or trademarks. Oral argument was held on May 4th, 2020. It was historic because of the pandemic. For the first time ever, the US Supreme Court heard arguments by telephone. We were very honored to be co-counsel with Booking.com. My co-counsel, Lisa Blatt, actually argued the matter on the telephone, and that was quite a new experience for her. Sort of like this is a new experience for us at the McCarthy Institute, where we're used to seeing you all in person, and here we are doing this from our homes all around the world. The Supreme Court ruled on June 30th. Next, Kelsey, in a decision by Justice Ginsburg. It was an 8-1 decision. And hopefully you've all read the decision or learned about it. We're not going to get deeply into the decision here because I assume some familiarity with it. But I think this is one of the key points from Justice Ginsburg's decision, where she made the point that it's really all about consumer perception. Consumers do not perceive the term booking.com as a generic term. People don't use terms like, oh, Travelocity is a booking.com. Rather, when booking.com is used, it's used in a clearly brand-like name. And next, there was a key footnote in the case. Kelsey, if we could just go to the next slide. There's a key footnote in the case, footnote 6, where Justice Ginsburg actually talks about the kind of evidence that's important, and it can include survey evidence. Indeed, there was a survey in this case where 75% of consumers or respondents who heard a traditional Teflon survey, they were able to notice that their view was 75% saw Booking.com as a brand name. But also, the court referenced other types of evidence that can be relevant, like dictionaries, usage by consumers and competitors, and other sources of evidence as well. And we'll talk about some of that today. Next slide. There was in one of the strategies we adopted in our briefing was to point out to the court all of the other brand names that would suffer if the PTO's per se rule were adopted. The PTO and the government relied on an old 1888 case, Goodyear, which dealt with the Goodyear company name, and said that if you combine a term like Goodyear with the word company, it's automatically not protectable as a trademark. We included in our brief an appendix of hundreds of trademarks that the Trademark Office had already registered, some very well known, some less well known. This is just a tiny sample of them. And we made the point that if the Trademark Office rule were adopted, not only would Booking.com not be registered, but tons of really distinctive marks that have been on the books for years as registered trademarks would be lost. Next slide. There was a dissent by Justice Breyer. He was the only dissenting justice. As I noted, it was 8-1. Justice Breyer first had some comments on the surveys, and we're definitely going to get into this. Really a concern about de facto secondary meaning. Just because the public associates a term doesn't automatically mean it should be a brand name. A concern that if you spend too much money, you shouldn't be able to take a generic term out of the common vocabulary. And in addition, on the next slide, Justice Breyer also had some concerns about competitiveness. His concern was that it would be anti-competitive if generic.com marks were able to get a monopoly. So we're going to explore a number of these issues today. Next slide, Kelsey. We've got an extraordinary panel lined up for you. First up will be Hal Perrett. Hal is a very experienced survey expert. In fact, Hal did the survey in the Booking.com case that ultimately helped the court conclude that, that the mark was in fact a mark. We'll also hear from Rebecca Tushnet at Harvard. Rebecca was an associate actually at Debevoise and Plimpton many years ago, so I've had the pleasure of knowing Rebecca for a very long time. Not only is she an extraordinary scholar and does she have a leading blog, but in addition, Rebecca has been very active in amicus briefs, and she did submit an amicus brief in this case, raising a lot of the very concerns that Justice Breyer latched onto in his dissent. And then third, we'll hear from Professor Peter Golder. Peter is a professor of marketing at the Tuck School of Business at Dartmouth. And Peter also submitted an amicus brief. His amicus brief was submitted on the side of Booking.com. And his brief actually talks about the other kinds of evidence that can be relevant. So I look forward to moderating this discussion. And why don't I turn it over to Hal?
Thanks, David. So for the survey in the Booking.com case, I used a version of the Teflon survey that I adapted for the particular issues raised by a .com suffix. It had been observed in previous cases that since consumers know that any web address can only be used by one company, that there might be a bias to answer that any .com term is from one source and could not be a common name. So the survey was designed with specific measures to account for this. If you could go to the next slide. In the initial portion of the survey where respondents are educated, could we put the next slide up, please? Yeah, and so what you can see here is in the initial portion of the survey where respondents are educated about the difference between a brand name on the one hand and a common name on the other, I incorporated examples of .com terms to show that .com terms could be either. So staples.com was listed as an example of a .com term that is a brand name. And on the other hand, officesupplies.com was listed as an example of a .com term that is a generic term. And giving examples of both .com brand and .com generic terms was intended to make clear to respondents that not all .com terms are brands, and that a term like officesupplies.com is a generic example. And if you could go to the next slide, the main survey tested the term booking.com in connection with a relevant type of service, which was described as hotel and other lodging reservation services. And if you could go to the next slide, we see the results, which was that consumers were strongly in favor of classifying booking.com as a brand with nearly a 75% result. Now, the second major mechanism for accounting for any bias to answer that any .com term is a brand and not a common name was to include a clearly generic .com term as a benchmark. And the term washingmachine.com was included as a control to measure the tendency to answer that a .com term is a brand, even when the term should be considered generic. And if you go to the next slide, we see the result. This was the result for washingmachine.com. And the 33% result for washingmachine.com quantifies this bias and allows us to account for that in the analysis. And it shows that even though there is some significant inflation of the brand result for a generic .com, the overall result is still accurate. In other words, it still primarily categorizes the generic .com term as a common name rather than a brand. And so one way that the washingmachine.com result accounts for any bias is that the pattern of responses for booking.com and washingmachine.com can be directly compared. And if you go to the next slide, what's clear from the results is that booking.com and washingmachine.com produced essentially opposite results. The result for booking.com was heavily in favor of brand, and the result for washingmachine.com is heavily in favor of common name. And what this shows is that the overall result of the survey properly classifies a generic .com term like washingmachine.com as a common name, and that the opposite result that booking.com got cannot be attributed to any bias to simply call any .com a brand. Now, the USPTO and the dissent highlighted this 33% result for washingmachine.com as a concern about the survey, but my view is that this misunderstands the significance of the control, because a substantial noise level like 33% doesn't reflect a problem with the survey. It reflects a real-world bias that the survey needed to successfully measure and account for. And quantifying that bias that's reflected in the 33% result was an important part of the design, and it allowed us to see by comparison that the result for booking.com stands up as a brand even when it's measured against this bias. If we could go to the next slide, the second way that the washingmachine.com control functions to validate the result is that it allows us to look at the result for booking.com among only the subset of respondents who correctly answered that washingmachine.com is not a brand. And as we see here, even if we look only at that group who did not call washingmachine.com a brand, booking.com was still classified as a brand by a 2-to-1 margin. And this further demonstrates that the brand result for booking.com is not attributable to a bias to call any .com a brand. So the other big concern that David already noted and was expressed in the dissent is that perhaps the 74% result for booking.com reflects a degree of secondary meaning that it's developed and not a lack of genericness. And this is a more fundamental problem in the case of websites that may have high awareness, since consumers can't leave behind their pre-existing associations when they enter a survey. So if we could go to the next slide, what are some possibilities for potentially accounting for some of these issues relating to .com names? One pertains to the educational portion of the Teflon survey. A survey could do additional education and provide additional examples to make even more clear that .com terms can be generic. .com terms could be incorporated into the mini test that respondents must pass to qualify for the survey. Respondents could also be asked about a clearly generic .com as part of the mini test and get that right in order to qualify. And we could even go so far, which I have done in some surveys, to just make the entire survey about .com terms so that all of the educational section and the examples and the whole mini test are about .com terms. And this can make it very clear that .com terms are not all brands just because only one company owns a domain name. The other thing that I've explored that could maybe be done is to change the answer choices. So instead of asking about, is a term a brand name or a common name, we could focus the analysis on distinguishing between descriptiveness and genericness, which is something I've done in other surveys. Because if the debate is really primarily about whether a .com term is descriptive versus generic, respondents could be asked to classify the term into one of those buckets rather than into the brand versus common bucket. And this would avoid the bias to call a .com a brand and force the inquiry toward looking at the line between descriptive and generic. It might also be possible to do something in surveys to account for the concern about secondary meaning, which was raised in the dissent. It may be possible in some surveys to ask respondents whether or not they've previously seen or heard of the term in order to distinguish between respondents who are answering that it's a brand based on their previous knowledge of the .com term versus reacting to a term that they have never heard of previously. If it's possible to have a substantial and representative subgroup of people who are not previously familiar with the term, we might be able to weed out any influence of actual secondary meaning by looking at the result among the subgroup. Or one other possibility for dealing with secondary meaning concerns is to ask those who answered that the term is a brand and were previously aware of it, another question to distinguish between whether it's a descriptive term that has acquired some secondary meaning versus a generic term. They could be asked whether the primary meaning of the term describes characteristics of the products or services that are offered versus whether the primary meaning identifies a type or category of product or service. And that way, even if there is a chance that secondary meaning is influencing the results, we could still distinguish between the perception that it's descriptive versus generic. And with that, I will pass it off to Rebecca.
Great. Rebecca?
Great. Okay. Hopefully I am eventually going to start my video. There we go. So thanks for this really useful introduction, and especially given the result, really a set of really important questions. So I'll say some things about this survey generally and what we might think about going forward. Actually, I think I've seen the comments already. I will note that the initial report here relied on the 74.8% total response for Booking.com as a relevant number. If we actually put washingmachine.com in control, it would be net 44.8%.
Rebecca, can I interrupt for a second? You're really breaking up with your audio.
Okay, let me turn off my video. Sometimes that may, let me see if that helps any.
Thank you.
The key issue, I think, under some circumstances, is whether that really was a control. If it was if washing machine control, and we're looking at 44 net, that matters if only one holds the threshold over 50%, the consumer group is the correct threshold for showing that the primary is as a trademark. I will say, realistically, measuring brand awareness is probably going to be hard in a Teflon survey for the reasons Hal gives. It's primarily directed at a different question. The majority does explicitly say it's not reaching the survey criticisms because of the PTO's concessions. And so I think these suggestions surveys are very important. So a few specific comments. What's really notable about all these proposals is they have understandably skipped over really the question of whether there is something called de facto secondary meaning left, right? So if the doctrine still exists, then the legal effect of the is what's at issue. So the interpretive question would be, what make people who say as 1/3, yes, still bad?
David Franklyn, it's still bad. I don't
okay,
know.
hang on 1 second. Give me 1 second to try something.
Okay, thanks.
Okay. I tried. Was my son stopped playing? Yes. Did that help at all?
It's still a little bit choppy, but why don't you proceed and we'll.
Okay, let me, all right, I have one more thing I can try.
Thank you.
Sorry about this. Of course, this didn't happen when we tried this out. It never does. Okay. Any improvement yet?
Yes, so far.
Great. Okay. So, the thing that I really want to focus on is that the interpretive question that we face now is, what do we do with people who say, as seems to have happened with WashingtonMachine.com, or a third of the whole? I've never heard of this particular generic.com, but forced to choose between generic, brand, and not sure, I'll go with brand. So if domain names are not inherently distinctive by virtue of being domain names, which I think is still an open question, it may be necessary to offer a fourth option to make a Teflon survey work. Something like neither a brand name nor a generic word. And I think a number of Howell's suggestions go to that question. I don't know. Can people actually be trained on the it'll be interesting to see. Are that may be a bad idea. But you know, if you think about the suggestive distinctive line and whether you can confidently predict the outcome of any given case, the suggestive distinctive line, you know, if we can't get useful answers from 5 minutes of training an ordinary consumer, we'll have to look elsewhere for the distinguishing principles. So one possibility worth talking about, I think, is using Likert scales. So Likert scales are where people give answers and then rate their degree of certainty. And using Likert scales can reveal a lot about where respondents are basically guessing. Chris Sprigman and some other people have been doing work on this and have discovered if you replicate genericity surveys with Likert scales, you get some very interesting differences from when you don't let people tell you how certain they are. But the larger problem is the still uncertain issue of de facto secondary meaning. So if the Supreme Court opinion means there's no remaining doctrine of de facto secondary meaning, then you don't even need the WashingtonMachine.com control, right? If there is still such a doctrine, then the survey shows it may not be possible to ask consumers questions they can reasonably expect it to answer. So, you know, in the survey we have, respondents were trained on the brand generic distinction. They had to have classified screening examples correctly in order to have their responses counted. And these people uniformly got supermarket correct, and 398 out of 400 got sporting goods correct. If 30% of those people who clearly understood the test still considered WashingtonMachine.com to be a brand name, when lawyers, the law agrees that it lacks trademark function, then this type of survey may simply not work for the relevant question. To put it another way, post-decision, a Teflon survey will likely always produce the result not generic for a generic.com. But not generic is not necessarily the same thing as a trademark. And so here I want to make a move, especially given the PTO's increased and welcome attention to trademark function. We may see much more attention to whether trademark function has been shown. Bold applicants may argue that the court majority at least implicitly endorsed the district court reasoning that domain names are usually inherently distinctive because everyone understands they're exclusive. But trademark function is a requirement even for matter that could in theory be inherently distinctive. So we might see more attention to that point. And I think actually something in this area that suggests something about European and also
Rebecca,
yes.
yeah, I'm going to jump in.
You know, it might be that you're leaning into the computer. If you sit back a little bit, it might be.
So I'm sorry you can't see me. I'm a couple of feet away. I can try and call in. You know.
Why don't we try that as a backup, Rebecca? And in the meantime, let me pose a couple of questions to Hal while we try to get you back online that way. You know, Hal, one of the issues that came up is around washing machine. One question which is pretty interesting is why did you use a compound term, washingmachine.com, rather than a one-word term like, you know, transportation.com or reservations.com?
Well, what I really, you know, one word versus two word wasn't as much of a consideration. It was more, I was trying to use something that is clearly a very common household item, a term that everybody is familiar with exactly what it is and how it applies to something, so that washing machine would be understood, for exactly what it means, and that it would be perceived as that people would understand that washing machine for washing machines is generic.
And I know that this actually came up in the briefing, and indeed Rebecca even mentioned it in her amicus brief, but there's a question as to why you didn't subtract the 33% brand name results for washingmachine.com from the 75% for booking.com. Why instead was your analysis to say, what if we disregard those people?
Because an analysis where you subtract a control result does not work for something that is fundamentally measuring a ratio and not an absolute number. So for instance, if you have a clinical experiment where you have 50% who say a medication helped their headache and a placebo shows a 10% rate, then it makes sense to look at the 40% difference above placebo. But here, since really what's fundamentally at issue is the ratio of brand to common, if you simply subtract a control number from the brand result and reduce it, but you do nothing to account for the common part of it, you're just arbitrarily altering the ratio and you're coming up with a number that is arbitrary.
So what I'd like to do is, we're going to circle back to some of these survey questions, but as footnote 6 of the court's opinion notes, there are also other types of evidence that can be considered, and indeed in some cases may even be more relevant. So I'd like to ask Peter Golder, who submitted an amicus brief, who actually addressed a lot of this other kind of evidence, to talk about the voice of consumer evidence.
Thank you very much, David, and thanks again to the McCarthy Institute, David Franklyn as well, for having me here today. So could we go to the next slide, please? The title slide, perfect, thank you. So essentially, I've been doing research with archival evidence for about 30 years now. It's been the foundation of my academic research and my peer-reviewed publications. And I was doing this, long before I knew it would be relevant for a Supreme Court decision. And over the last 6 years, I've also applied some of these methods in multiple expert witness assignments in litigation. Next slide, please. So as David mentioned in this footnote 6 essentially calls out alternative sources of information. So surveys are great. They're required in most of these cases, but they're not the only piece of evidence. And the Supreme Court in this footnote 6 really called out a variety of other sources of evidence. And essentially my talk really is going to be elaborating on those sources of evidence, how they could be applied in cases such as this one, and also how they could be applied in other cases. But essentially, archival data represents a veritable treasure trove of information that can bear on consumer perceptions, can bear on consumer usage, competitor usage, and I just want to give you kind of a flavor for that, the type of data and type of analyses that can be done in my brief talk today. So next slide, please. So back in 2000, I published this article in Journal of Marketing Research about how to specifying a method for how to analyze archival data. And I'd just like to say at the outset, every method, all research methods have strengths and weaknesses. So it's important to have carefully designed surveys, of course, but every method will have its strengths and weaknesses. So this first point about triangulation is really this idea that when you use multiple methods, multiple data sources, that you can overcome some of the weaknesses that are inherent in any method. And this idea of triangulation is important in academic research to really try to get close to what the truth is in any situation. So at a minimum, I would say that you can view archival analysis as complementary to survey research for just about any research question in academics or in litigation. The next point about ecological validity, I would say this is a strength of archival analysis because essentially the data are created in their natural setting. They're not created in a research setting. The data are created in a natural setting. And then the third point is really related to this is that archival evidence exists independent of any investigation. So those of you familiar with philosophy of science, know that whether or not you're talking about physics research or anthropology research, when you try to measure a phenomenon, there's the chance that you will be kind of influencing people by the mere act of measuring it, kind of a mere measurement effect. So one of the beauties of archival analysis is that the data exist really independent of a researcher's investigation of that. The data are created, separately from the process, and when the researcher comes in later to investigate those pieces of data for the research question. So next slide, please. All right, so now I have a little pop quiz for you. It's the professor in me. So take a look at these quotes, and these all come from a publication, a well-read publication in the 1960s called Financial World. So I want you to think of the one company that comes to mind. These quotes are all describing one company. So everybody have a name in mind? All right, next slide, please. So the company being referred to in all those quotes is Howard Johnson's. And, most times I present to, an audience, most people are thinking McDonald's. The archival evidence is quite a bit different and gives you a sense about sort of, how important it is to be an early leader in a category, how categories evolve over time. But, there's a lot of insight that comes from these analyses. And next slide, please. So here we're back to the court decision, and essentially here they're highlighting consumer perceptions and consumer understandings and consumer behavior. And I want to give you some sense of the archival data that's available to address those issues. So next slide, please. So here's some data that comes from tweets, and essentially here you can see consumer perceptions and understandings. In the context of this case, these tweets are referring to Booking.com as one among several members of a class. So not the class itself, but you see the other members of the class like Travelocity are on here, and that gives some insight into this case in particular. But more than anything, I'm really trying to give you just a small sense of the type of data that's available. So there's a voluminous amount of tweets that are out there that can be analyzed. Next slide, please. Here's one example of a consumer review. And the key point I want to point out here is not really the quote itself, but the idea that from just one website, there are, I believe the number was over 3,000 consumer reviews of Booking.com. Then there's also going to be thousands of reviews of the other travel websites. And if you want to hear the voice of the consumer, if you want to understand how consumers perceive and how they use certain terms, whether they're category names, names of class, members of a class, there's a voluminous amount of information here to address those questions. Next slide, please. And here's another way to get at the voice of the consumer. So the Supreme Court decision talked about consumer search, and sometimes consumer search by asking their friends. The way most people search today is using a search engine, Google in many cases. And here you can see how the relative search with Booking.com as a term, how that changed over time. You can look at this in relation to other terms, name of class terms, member of class terms. But again, here you get a sense about how consumers are behaving in using these terms. Next slide, please. This is just an example of traditional media that's also bearing on the name of the class. So you have video conferencing or a member of a class, Zoom in this case. So again, just another source of data that can be used. Next slide, please. So on this slide, what I want to do is just give a very quick overview of one type of quantitative approach that could be used. So one of the key things I want to stress with the archival analysis is it's not just a compilation of anecdotes. If this is done properly, it can result in quantitative analysis, and it can be compared against benchmarks. So essentially, this is showing that if you look at 100 consumer reviews, you can count the number of times that you see the name of class along with a member of class, and compare those to benchmarks, basically based on prior court decisions and TTAB decisions, and get some real insight as to whether or not a term is generic or non-generic. And next slide, please. And the last point I really want to touch on is this over time piece. Because again, archival analysis is particularly suitable for over time analysis. And next slide, please. And there's something called the Internet Archive Wayback Machine. And here we're looking at Hotwire back in 2012. And again, seeing evidence of name of class and member of class. As of course, the Supreme Court decision also highlighted competitor usage as being an important source of information. Next slide, please. Again, here we see Wayback Machine information on another website from 2013. Next slide, please. And this is one of my favorite examples coming from my research. So the so-called portable electronic still camera doesn't look quite so portable, but that was the name initially. And it took many years really till this people coalesced around the term digital camera. So this just gives a sense about how over time there are these changes in category names and potentially multiple names being used simultaneously over some of this time. Next slide, please. And this is my final slide, really. I just want to sort of close the loop here and talk about how archival evidence can be used in litigation. So, carefully designed studies are capable of producing, valid, reliable information. They can pass the scientific, peer review process at journals, and they are capable of being very persuasive in litigation matters. So this particular slide comes from the Amazon transfer pricing case, where I compiled archival data, used this data in a hazard model, a type of econometric model, and came up with an estimate for useful economic life of a brand, roughly a decade in time prior to actually conducting the analysis. So that's part of this time machine aspect of archival analysis, and the court found this evidence to be most persuasive. So really, in conclusion, there are three main points. Really, is that archival data represent a treasure trove of information, representing the voice of the consumer, representing competitor usage. Archival analysis can act as a time machine of sorts, enabling researchers to focus on any time period from today going back decades. And archival analysis can provide reliable, valid, quantitative results that courts have been able to rely upon. And now the Supreme Court has really pointed out as being a valid type of data and a nice complement to survey research to be used in cases like this one, but also in many other situations. So thanks again for inviting me, David.
Great. Peter, thank you so much. I think it's interesting to see how the survey evidence and the voice of consumer evidence can interact. I believe Rebecca is back on the phone with us. Rebecca, let's see, are you able to be unmuted? Let's see if we can hear you.
I sure hope so.
Yes, perfect.
How are we doing?
That's great.
All right.
So I wonder, in your amicus brief, you certainly commented on the survey evidence, and you raised some of the kind of concerns that we've seen in some of the questions, obviously that Hal has addressed, but there was some concern by the court. Justice Sotomayor, who in fact was an IP litigator before she became a judge, and so a lot of IP cases in the district court, she suggested she might have seen this otherwise, but the legal question presented to the Supreme Court, was answered properly, even if the factual question is different. I wonder if you have thoughts on the kind of voice of consumer evidence that Peter has just described, and whether that would alleviate some of your concerns about de facto secondary meaning, or whether, in your view, that would just be another way of showing that there's association, but actually not brand significance.
Right. So, I think absolutely this kind of evidence is relevant. Let me raise a point of research interest at least. So what kind of results would this methodology have produced in a test set of the genericity cases that we all know and love, right? I think that would be a really interesting question. Even if there's a mismatch, by the way, I don't think that invalidates the methodology. It may be that courts got it wrong, but I'd be very interested to see what the methodology did for cases like Hog, for large motorcycles, and the other cases that we tend to think about as foundational. Even something, the archive might barely be enough to get you something on something like shredded wheat. But I also think, there are a couple of normative issues that remain. First, there's a question of usage versus comprehension, right? And this is something that's always stood out to me about the Teflon survey, which is, there are a lot of people who have no idea what else to call Teflon until you say non-stick to them. And then they're like, oh yeah, I know what that means. And that is an important distinction. I also think, yeah, as you suggested, it's really the issue is de facto secondary meaning a thing anymore? If it's not, then one should have no hesitation at all about using this, because this is an excellent gauge of secondary meaning. No, I don't think we have empirical tools that are particularly good at sorting out de facto secondary meaning from de jure secondary meaning, because it is a legal concept. So, no amount of additional evidence will help us if this concept still exists, which it might not. I think that's a big, open question. And if it's not, we'll have to turn to a bunch of other legal tools, including ones for managing scope, which I hope we'll get to talk about.
So, a lot of the other issues in Justice Breyer's dissent dealt with those concerns of being anti-competitive. And I wonder if you might address your concerns with what the Supreme Court's decision means for competition law.
So the question that I have that is teed up is, if washingmachine.com might be inherently distinctive, or even even if it's not inherently distinctive, if all you have to do is advertise it a bunch and then you'll get protection, what happens to the person who's running washingmachines.com? Is that confusingly similar, and how will we know? So the court, the majority deferred all questions about the scope of the mark to the infringement inquiry. And this is, I think, legitimately concerning. So, for example, Free Cycle, which has a case in the Ninth Circuit deeming the term free cycle to be generic, the main organization running free cycles then got a registration for freecycle.org, and then started sending takedown notices to Facebook pages that didn't use freecycle.org, just used the main term free cycle. And that's not clearly precluded by much in current doctrine. The majority says that this risk attends any descriptive mark, but it's important to note, not all descriptive terms are comprised of generic components. Well, one need not use soft to sell one's mattresses. One generally must use mattress to do so. So mattress.com poses a very different risk with respect to competition than soft mattresses incorporated. So one open question that I think is worth thinking about is, will courts use plausibility to put an early end to such cases? Because we all know if you go to summary judgment, you might as well have lost in many ways if you're the defendant. The other thing that I think will be quite doctrinally relevant is prosecution history estoppel. Well known in patent, unknown in trademark until recently. I suspect that booking will increase both the PTO and the court's interest in the concept. I just want to mention two important examples that we had pre-booking. Bottega Veneta had an application to register a specific width and angle of basket weave for shoes and bags. The PTO did grant that, although there was a successful opposition with respect to one of them, but with an explicit statement that the registered rights would not extend past the width and angle of straps exactly specified in the registration, something the PTO doesn't usually say, and it's not clear that the PTO can enforce. Second, the Let Us Turn Up the Beat case, which is now on appeal in the Ninth Circuit, the district court said that where the PTO had found that a phrase failed to function as a mark when it was used to decorate a t-shirt, but did function as a mark when it was on a hang tag, the court would not then find liability for the defendant's use on the front of a shirt, which was not trademark function. So I suspect that claims that applicants make to get their registrations, like Booking did, that it's not going to assert its rights against variations like LondonBooking.com, courts in the PTO may start to see a competitive need to enforce these concessions, which they haven't previously in trademark. So that's what that's what I think are interesting questions going forward.
Thanks, Rebecca. Kelsey, why don't we go to the next slide? Because I'm curious to know what our audience thinks about these competition issues. Certainly the government made a big deal about it. I think Rebecca and some of the amici on the side of the government highlighted these. So the question we have for our listeners is, how significant do you think these competition concerns are? To what degree do you think the registration of generic.com marks that have been shown to be distinctive and have shown to have secondary meaning will create competition concerns? So why don't everyone please vote? The panelists can't vote, so this is going to reflect the 400 or so of you who are with us. And I'm going to close the poll in a couple of seconds. So please take a stab, put your vote in, and 3, 2, last chance. Okay, Kelsey, let's see how people responded. So very, very small number think it's not significant. But it seems like in the sort of significant to very significant to extremely, it's certainly well more than half. Peter, I wonder if you could comment on that. And why don't we advance to the next slide, Kelsey?
Sure, thanks, David. So this is an interesting point because it's very related to a lot of the research that I've done over the years, which is essentially looking at market leaders. And there were these questions raised during the oral arguments about the competition concerns. So I just wanted to share one slide, basically looking at some internet-based markets or some technology-based markets, and see how important is it to have a generic brand name or generic .com brand name. And in this data set, as well as the, I mean, I've looked at hundreds of categories over more than 100 years. I mean, you just don't see generic names, generically named companies or generic .coms being leaders in a category. And so what this chart is showing is it's showing the brand leaders in each of those categories, the market share leaders over time in each of those categories. So if you look at a category and go down that column, that's how the leadership changes over time. You're just not seeing the competition concerns. I'm not seeing the competition concerns in all of my research that were being raised from the bench.
Thanks, Peter. The other thing that Rebecca touched on is mattress.com versus, let's say, soft mattresses. Kelsey, let's go to the next slide, because I wonder if folks think, in light of the Supreme Court's decision, that mattress.com might be decided differently today. So let's put that poll up. Do you think mattress.com would be decided differently today? Yes, if you think that mattress.com would get trademark rights today. No, if you think that the decision that mattress.com is not registrable would stand. So everyone take a quick shot at that. I'll give you just 2 or 3 more seconds. Last chance. Okay, Kelsey, let's see, how do we come out? Wow, much closer than I would have thought. Peter, what do you make of that?
Well, I think if you apply some of the principles, if you say, are consumers using mattress.com as a category name, if you apply that logic of the Supreme Court, and again, I'd want to, in all my research, I have to do all the analysis very thoroughly before offering an opinion, but one of my hypotheses going in is that you would not see a lot of consumer usage of mattress.com as the category name. So that would be, in line with the Supreme Court logic that it is more a member of a class than the class itself. But again, a thorough study would have to be done to investigate that from an archival analysis perspective.
I might also address one point that we've had a bunch of questions about, and also, I think touching on Rebecca's presentation, and that is, what is the scope of this protection? This was a question that the court asked Lisa during the oral argument, and she made the point that there are other booking trademarks already registered, like ebooking.com, which has a very distinctive design. And I believe there was a like fishandtacklebooking.com or something like that. And in oral argument, Lisa made the point, and this goes to Rebecca's point about prosecution history estoppel. So I think that this would be something people would hear about if booking were to get more aggressive. But they made the point that booking.com is really looking to protect its brand against confusing uses. There was an example in an amicus brief from the cars.com folks where they showed that a real brick and mortar dealer had a big cars.com sign outside, and they weren't affiliated with cars.com. Having cars.com registered as a trademark gives the ability to prevent that kind of confusing use. Similarly, there's issues with how you can enforce your rights under the UDRP. But I do think that there's going to be recognized limits on the breadth of your ability to enforce, because the trademark is still composed of very highly descriptive, if not generic, components. Booking is a generic term, let's accept, for booking things, and .com is a generic term for the top-level commercial internet TLD that we all know about. So the ability to prevent whether it's, booking dot some other DLD or hotel booking, it's really going to depend on the totality of the facts. And Justice Gorsuch specifically asked about this, and the response we gave at the oral argument is that there's a lot of mechanisms in trademark law to prevent against that kind of over-enforcement. Obviously, you have to show a likelihood of confusion. There's also the notion of fair use. And those are the kinds of trademark doctrines that I think will help to prevent this kind of over-enforcement. I'm cognizant that we've got about 10 minutes left in our scheduled time. We do have a lot of questions. So David, what I'd like to do is turn it over to you for Q&A.
Sure, thank you, David Bernstein. And there are a lot of questions here that we have coming in. Let me ask Rebecca, do you think this opinion can be cabined legally as holding only that a generic domain name or a highly descriptive domain name isn't necessarily generic just because it otherwise would be? Is there a way to read this case narrowly?
Thanks. Yes, I think the court does. I don't think the court completely forecloses the all domain names are inherently distinctive idea because it adverts the idea that having a domain name signals exclusivity, but nor do I think that it clearly adopts that view, right? At best, it just doesn't foreclose it, I think. And clearly, I think the better view, especially given the competition concerns, is at the very least, you've got to show secondary meaning. And, is there still any room for the concept of de facto secondary meaning? I just don't know. I don't think a court would be outright defying the Supreme Court to say there's still a doctrine of de facto secondary meaning, because the court does not purport to overrule Kellogg. And that's for sure. But I think part of it is we just don't know, and much will depend on the cases that courts actually confront. So to the extent that mattress.com goes back and then starts suing emattress.com, that's going to produce a different kind of case law than someone who sues only people who, fake a link to mattress.com and then redirect you in a spam email, right? So I think we'll learn a lot from the cases that come next. But since we've already seen things like Free Cycle, there will definitely be problems along the way. And most of those won't get to court, which is kind of the issue.
Yeah, I wonder, just to follow up on that really quickly with you, because we have a lot of other questions and we've got 6 minutes left in our scheduled broadcast, which we can extend by up to 15 minutes, we've decided, if people want to hang on after 10 o'clock. But for Rebecca, isn't there just a chilling effect here that we haven't really discussed? That once the court says this kind of mark can be registered, what incentives, how does that affect what people do? And maybe this is for the rest of the panel too. I'd be interested to hear what people think. What is there realistically a chilling effect here? I think that's what people are concerned about, not just competition in the purest sense, like do you need to use the word booking as part of your domain name to compete?
Right.
But isn't there a language sharing issue that now you're just not going to use it? And so are you going to be really shy about it because you're afraid and you're being counseled differently by lawyers because you're afraid, legitimately afraid. And was that concern, I guess, appropriately considered by the Supreme Court?
So again, a lot of this it really depends on what courts think are plausible claims. Honestly, I think if you anything that gets, as David says, if it's a all factors considered test, then most of the time you're going to have at least to develop a record for summary judgment. That's going to be a big deterrent. On the other hand, if courts largely say unless you are doing something else to suggest a connection. Just having the generic term and .com in your name isn't enough, or even worse, just having the generic component in the name of your Facebook page isn't enough. Then the law will develop differently. So much depends on plausibility. I don't think descriptive fair use is going to be any help at all, precisely because there's a bunch of doctrine at this point that says you certainly can't get out, like if you have it in your domain name, that's at least going to create a factual issue as to whether it's going to be used as a mark. And therefore, you'll just have to go through the whole confusion litigation, no matter what.
Thank you. There are a lot of other questions. Here's one. I think maybe it's best to put this question to our moderator, David Bernstein. What effect, if any, do you think this decision could have on the UDRP process?
That's interesting. I've been asked to speak on that at a conference in September for the sort of domainer community. And so I'll be giving that some more thought. But a key issue right off the bat is going to be that there's a lot of UDRP decisions that have said a generic.com is generic. And I think now we're going to have to recognize that generic, at least under US law, generic.com is not always generic. It might be merely descriptive. And so then the question will be, have you managed to get a registration? If you have a registration, UDRP panelists are going to usually be deferential to a trademark registration, and it would go through. But if you don't have a registration, then in the UDRP, you're going to have to come forward with some real allegations of fact to show acquired distinctiveness. And I think we in the UDRP, we don't have access to all of the discovery tools that you would at the PTO. I think it would have to be a pretty overwhelming presentation of facts to persuade a panelist that the mark is in fact, or that the domain name is in fact serving as a trademark. I will note, by the way, that booking.com was already registered in many countries around the world. And so in one sense, this brings the US into lockstep with other countries that had already recognized that a term like booking.com can be registrable. And I do think the key takeaway, and I've answered a bunch of these questions online through typed answers, and you can see them all in the Q&A area. I think the key thing is to recognize that the scope of this decision goes well beyond .coms and well beyond domain names. It goes to telephone numbers, it goes to addresses, it goes to hashtags, it goes to any term that's a combination of marks, like pretzel crisps, which is a case that was litigated up to the Federal Circuit, and indeed the Supreme Court cited that case. And the issue is not, is this trademark composed of terms or parts that are generic, but rather, what is the consumer perception of the mark as a whole? And so I think the impact of this decision goes far beyond just domain names, but really is a clarion call to how we are going to assess whether a term is generic or not.
Great, thanks. I have a question. We only have a minute left of our scheduled time. This is for Hal Perret. Hal, isn't timing a real difficulty here for a survey? That by the time it came to litigation and it came to do a survey in this case, booking.com was so well known and so well established that it's exceedingly difficult to separate that out from, what would people think of the term booking.com? Would they think it's common and generic, or would they think it's, a trademark or a potential trademark? The survey would have been done years ago, like at the beginning of the business cycle for a company like this. And I know that's a recurring problem in survey work, but how did you think about that in this case?
Well, it is a recurring problem. It's also one in secondary meaning surveys, where you're often supposed to be measuring whether something had secondary meaning as of a much earlier date. And the fact is, you can't go back in time in either of these contexts and measure it back then. It raises, two thoughts that I've had on the topic. One is, while ordinarily in trademark surveys, it's a requirement that the universe of people that you survey are the people who are currently in the marketplace for that type of product or service. Given this situation that we're talking about, there actually may be some value in interviewing people who are not in the market for it and would maybe have less awareness of it. There may be something to, as I mentioned before, if you were interviewing people who were not actually familiar with the business booking.com, or in any case, people who are not actually familiar with whatever the product or service is that it's at issue, then you would be getting more people who are answering based on their perception of the term itself and not based on previous awareness. So that's one thing that I've considered for addressing it. The other thing, since you can't go back in time, is, I mean, part of the problem is that, fundamentally, when you're asking, is something a brand, you are triggering people's associations with things that they're already aware of. So whether it may be of interest to do something in surveys to have a question that gets away from brand. Like I mentioned before, sometimes the issue is really just trying to draw the line between descriptive and generic, which is a very difficult, fuzzy line. But if what you were asking people is not, do you know this as a brand, but something that more forces them to categorize it into descriptive versus generic. For instance, does this name primarily describe characteristics or qualities of what's being offered versus does this name identify a type or category of product or service? That may allow us to get at that difficult distinction between descriptive or generic without importing everybody's pre-existing associations of whether something is a brand or not.
David, could I jump in here?
Yeah, I was going to ask you, Peter, to address that because you can deal with the issue of a history.
Right. So this is a perfect example of the archival analysis being a complement. Again, every method has strengths and weaknesses, but this archival analysis acts as a time machine of sorts. And going back to the Amazon transfer pricing case that I talked about briefly, I was estimating the life of the brand 10 years prior to the analysis having been done. If you're looking at a branding issue, secondary meaning issue, you can look at how the term was being used at a point in time. Rebecca raised this issue as well, that firms make efforts to establish secondary meaning. So the archival analysis allows us to look at, 2015, 2010, 2005, 1950, if you want to, and say, how were these terms being used at that time? So we can put ourselves in a time machine as such. And, the Federal Circuit in the Converse case raised this issue as well about trying to look at, historic secondary meaning, through being a challenge with surveys. And again, there are ways to attempt to address this, certainly. But the archival analysis can be a nice complement here because it does have this time machine aspect where you can look at consumer perceptions, consumer usage at any given point in time that you specify.
Thank you. David, if I can just jump in here, there's a question I'm seeing coming in from our virtual audience that I think may be best directed to Peter. The question is, what about letting the industry challenge whether or not a term is now generic or not? I think I would add to that sort of a follow-up at the beginning, which is, or to express its concerns about competition. What are your thoughts about that, Peter?
So, I'll have to think about this more as a marketing professor than a lawyer, because I'm not a lawyer. I would say my understanding is that concerns can be raised by people at various parts of the registration process and various parties. But my marketing take on this again is that brands try to differentiate themselves. They try to separate themselves in perceptual space. That's what we teach students in business school. It's not try to crowd into the same space. And I'm not saying that can't happen because it can happen in theory. And these close brand names may have a problem. But what we teach students in business school is to find brand names that allow you to differentiate yourself. And I think that's what you see in the travel space. So you see consumers clearly able to say, there's a booking.com, there's Travelocity. And notice that that site didn't, that consumer didn't refer to it as Travelocity.com. They referred to it as just Travelocity. So again, these are just, I haven't presented the full analysis that I would do normally, but this idea of how consumers use terms is meaningful, and whether it's other competitors or industry as a whole challenging it, that they could use this evidence just as well.
Peter, someone asked about whether this kind of archival evidence that you've used has been produced in discovery. How does this generally play out in the litigation context?
So I would say I have used it in multiple cases, and again I would point to the example that I showed where the Amazon one, where it was again it was people wanted to know about something that happened years ago, back in 2005, I believe. So how do you do that? There are other ways. You have to use archival data and basically say, at a given point in time, here's our sample. Here's what would have been known at a certain point in time. So whether it's life of a brand, whether it's secondary meaning, whether it's genericness, whether it's looking at member of a class versus class name, all these questions can be addressed based on the archival data that exists at a given point in time. So that time machine aspect is really quite unique, because you're setting aside whatever the company did afterwards. Whatever happens afterwards can't change the historical record. It exists. It's there for us to discover, and it's there for us to use. And I do think that when these studies are properly designed, again, like any method, requires expertise. You can't just wing a survey. You can't just wing archival analysis. When these studies are properly designed, they are persuasive to courts, and it's proven out that way.
Thanks. David Bernstein, do you have any other questions? I have a couple here I'm seeing, but if you have anything you wanted to raise.
No, I mean, I'm respectful of our presenters' time and of course the audience. We've already gone a bit over. Maybe we have time for one or two others. I'll just say that some folks have asked about CLE credit. So quickly, when you registered, you had the option to select CLE credit. But if you didn't do that at registration, just email into info@onesourcestrat.com. And I'll post that on the chat function in just a second, and we'll be able to get you CLE credit. Some others have asked about the slides, and yes, we will be sending those out as a PDF. And finally, this presentation is being recorded, and you'll be able to watch it again at your leisure on the McCarthy Institute YouTube channel. Back over to you, David.
Great, thank you. I think with that, we'll call it a wrap and let people think about these things. I think it was a great presentation. I thank all of our presenters, and we hope to stay engaged. So take care, everybody.